And you cannot hear Senator Randolph's questions because they muted it.
Senator Walker. Senator Head. Senator Buck. Senator Bray.
Yes. 5-1. Bill passes 5-1. Thank you very much. Now, I know we have caucus here in a moment, or actually 5 minutes ago, but Senator Buck, we have House Bill 1222. Do you think, how long do you think will your presentation take? Do you have?
Shouldn't take long.
Okay, let's try and move forward with it. If we have to recess till after session.
Thank you. House Bill 1222 comes to us as amendments to condominium and homeowners associations. We've dealt with these in the past years, but one of the things that it deals with, and I'll go down through the list here, it has to do with being able to send out these notices to the first mortgage holder, making sure they receive them. They have 30 days in which to respond. The other thing, it makes sure that the condominium co-owners have the right to attend any of the meetings of the condominium or homeowners association, including their annual meetings. Tells about having the uniformity within it, where if there is an association prior to, I think it's about 7 years ago, they also come under the provision so that no matter where you're at, these comport with it. It allows for the Attorney General, should anybody have to bring suit, that there's a $500 civil penalty. That's the maximum that can be levied. So it's pretty straightforward. If you've got any questions, the Attorney General's office is here with us. Be glad to entertain those.
Senator Randolph.
Yes.
Does he? We can't hear anything he has to say.
That would be yes, Senator. That would be a violation of the statute. Currently, we already have authority where there has been either bad action, bad behavior, if you will, by a board or board members, and there are the remedies under current law. This is simply adding a $500 penalty, which was omitted previously for violation of the proxy statute. So this is a limited change. We already have the authority, and if they do not comply, then we have existing enforcement authority.
What are the penalties?
Well, injunction, cost of investigation, a civil penalty up to $500, and there is a restitution provision, but this particular case, it's for violation of proxy, so it wouldn't be a restitution issue. So
this particular case, I'm just saying if they go beyond the authority,
right,
that this gives what penalties exposed to them. I mean, who's to say they can't continue to do that? Can you?
Well, we would have authority to stop their behavior. An individual would still have a private cause of action of their own, but the statute gives us the authority for violations. That's existing law.
I can't believe what I'm hearing.
Thank you, Mr. Chair.
Any other questions from members of the committee?
Thank you, Mr. Chairman.
All right, Mr. Bushman, would you care to comment, please? Thanks for being here.
Steve Bushman. I'm a volunteer member of the Legislative Action Committee for the Indiana chapter of CEI Community Association. I represent the boards. We support the legislation as it currently is. It's a good mix between the two, and we think it'll work for everybody.
Do you have a question or concern, or do any of the HOAs have a concern about bringing older homeowners associations more into the loop of these new statutes that have passed over the last few years?
In many cases, it would certainly be nice. A lot of the things like the amendment provisions and things like that, where the homeowners associations, quite frankly, have been tied by what the developer originally wrote, that would make a lot of sense. Technically, you can't go back and amend the contract, but there are certainly a lot of times that would make a whole lot of sense.
Does this do a little bit of that, though? I guess when I was starting to look at it, I didn't quite understand exactly what it did. But if you look at page 3, maybe this isn't part of it that does it. Page 3, line, say 18, which is a subsection B there. Is that not including?
I think those are the sections, I went through those, those are the sections that already apply to everybody.
They're
Grievance
already there.
procedure- Yeah, they're already
Okay, so
there.
you're not adding
It's-
new ones?
No, they're not
Okay.
adding new stuff that goes back.
All right. And then, Mr. Miller, is that, you're nodding your head, is that?
Have always been, so this would not change.
Okay, so because I didn't go back and look at those. So those are the ones that already apply retroactively back to older homeowner system. Okay, thank you. Any other members of the committee have any questions? Okay, gentlemen, thank you. Senator Buck to close? All right. Committee discussion?
Second.
Okay, call the roll, please.
Senator Taylor, Senator Lannon, Senator Randolph, Senator Pete Miller, Senator Alting, Senator Young, Senator Walker, Senator Head, Senator Buck, Senator Bray.
Yes.
Passes 6-0.
Okay, thank you all. Thanks for the committee and for getting all this done this morning. Be honored. No, we're done.
Oh, they showed his face. Okay. We'll have to retake that again.
Wow. Did you hear all of that? That's HB 1022. 1222. And this is unbelievable. That was the IGA, Indiana Attorney General, Stephen Bushman, plus Burke. And this was co-authored by Randy Truitt. Randy Truitt is the owner of the management company that was involved in the lawsuit against us. This is significant because of what HB 1022 does to homeowners.